Yes, Mr. Manford.
Thank you, my lord. So I'm going to start now on the first of my 5 headings that I outlined, and that is the question of the purpose of the directive and the framework agreement. And my headline points here are, first of all, that there is nothing to suggest that the use of the word solely because in clause 4.1 of the framework agreement as part of the directive was not used deliberately, and that ought to be given effect in looking at the PTWRs. Secondly, that accords with the limited purpose of the directive. And thirdly, that the purported broader protective purpose of the directive is not sustainable when one looks at how this directive came to be and as to its terms. So the starting point is, as I said out in my skeleton argument at paragraph 23, it was accepted below, as stated in McMenemy, that the tribunal was required to purposively construe the regulations in light of the directive, i.e. that is the relevant interpretive obligation. And we see in McMenemy, if we take up the authorities bundle, and that's at tab 7, page 152, paragraph 5 starts in the middle of page 152, and the court can see there that there is reference to, from the words the court paragraph 55 referred to articles 2.1 and 5.1. It sets out parts of the directives. Then it says below, reference was also made to Lister versus Forth Dry Dock and Engineering Co Limited, in which the House of Lords held that the UK courts are under a duty to give a purposive construction to directives and to regulations issued for the purpose of complying with directives, and Webb and EMO Air Cargo UK Limited, in which Lord Keith said it is for the United Kingdom court to construe domestic legislation in any field covered by a community directive so as to accord with the interpretation of the directive as laid down by the ECJ, if that can be done without distorting the meaning. And then over the page at the top, this is consistent with the approach laid down by the ECJ in Ficini Dori. When applying national law, whether adopted before or after the directive, the national court has to interpret that law. That law must do so as far as possible in the light of the wording and purpose of the directive, so as to achieve the result it has in view, and thereby comply with the third paragraph of Article 189. So that reference there in Ficini Dori to interpret the domestic law in light of both the wording and the purpose, and in my submission that is what the court has done in McMenemy in having regard to the wording of solely in the directive and the wording in the regulation, which I'll come on to deal with, which echoes that, and also in its consideration of purpose. So the EAT below, and we can see this at page 57 of the core bundle, recognise that Paolo Ficini interpretive obligation. You can see that set out there at paragraph 68. We recognise that the PTWR were intended to ensure the UK's compliance with the PTWD, and that we should therefore approach questions of construction as far as possible in the light of the wording and purpose of the directive, so as to achieve the result it has in view. So, in my submission, that is a very important starting point. It reflects what the parties were agreed on in McMenemy as to the appropriate approach for the court in that case, and I said that was correct for them to do that. My Lord Justice Edis posited to my learned friend that there was perhaps more detail on purpose being put before this court than perhaps before McMenemy, other than giving effect to the wording, so the purposive aspect of Ficini Dori, which refers to in light of the wording of the directive. But I will say that it also accords with the purpose, and this court is in the position to hear argument from me and my learned friend as to what one can glean as to purpose from looking at the context of the directive. We don't know what was put to the court in McMenemy, and it may be that a broader range of arguments were canvassed and ultimately reflected in the decision. for judgment, not needing to canvass every argument on well-established principles. But in a way, I say that's nothing to the point, because the court can look at that issue anyway now as part of its approach at the end of considering whether my learned friend has established that, to the court's satisfaction, that the decision in McMenemy was wrong, clearly wrong, and whether that amounts to compelling reasons to depart from it. So,
but we don't know, do we, whether whether the solicitor advocate appearing for the appellant in McMenemy in effect conceded that you should interpret domestic regulations on the basis that they must, of course, go as far as the directive, but that you interpret them on the basis that they don't go any further. The second sentence rather suggests that it was not only common ground that the Ficini-Dori establishes the proper approach, but it seems to have been common ground that the regulations went no further than the directive. But that begs the question.
Yes, on that limb it does, and yes. I'll come on to address why I say there's no factual basis here, looking at the materials, to suggest that the intention in enacting the regulations relevant to the issue of causation was to go any further than the directive.
All right.
I'll come to that as my third topic. So before we go deeper into these issues of purpose, let's just look at the process of construction that the Inner House undertook in McMenemy. So if the court can take up McMenemy in tab 7, and that we'll start looking at page 151. So in 151, at paragraph 3, the court said there was some discussion before us of the significance of the word solely in clause 4.1. Now, I accept that there's not a very detailed description of all of the arguments that may have been put to the court in relation to that, but there's reference to that discussion. The court goes on to say, reference was made to versions of the directive in a number of other languages. It is sufficient to refer to the French, au sol motif, and German, ne des Wegen, versions to reinforce the impression that would be gained from a straightforward reading of the English version that solely does indeed mean that the less favourable treatment of part-time workers, which is prohibited by the directive, must be the reason that they work part-time, and for that reason alone. Now, what I say about that is one can glean that there was a degree of content to these submissions. The council has obviously put before the court the different language versions. The court has looked at the different language versions to try to ascertain whether the word solely, perhaps if the directive was originally drafted in an edition in another language, is somehow not reflective of the language versions in the other versions of the directive, and it's considered that in fact solely reflects the wording in the other language directive, in the other language versions of the directive. So the court's impression from that is that reinforces what would be gained from a straightforward reading of the English version. And it may be that when one looks at regulation 5.2, and if we just turn that up in the authorities manual as well.
Has it changed? McMenemy does set it out.
If one looks at regulation 5, which is page 417, and subparagraph 2, it may be there that the wording, the right conferred by paragraph 1, applies only if A, the treatment is on the ground that the worker is a part-time worker, and B, the treatment is not justified on objective grounds. It may be that language of applies only if, as my lady said earlier, was an attempt by the domestic draftsman to reflect the wording of solely because in the directive.
You could do, but you could have said the right. Why not say under A, the treatment is solely on the ground?
Yes, it might. But if one compares it, for example, to Section 13 of the Equality Act on direct discrimination, the wording of that is a person A discriminates against another B if, because of a protected characteristic, A treats B less favourably than A treats or would treat others. So one doesn't see that echo of the wording of only if.
But only if qualifies both of the following.
Yes.
But in the framework agreement,
Yes.
the word solely is only for the first one.
Yes.
So it doesn't have anything to do with justification, but in the regulations it does.
Yes. The point, if one asks at the justification stage, would the only if add anything additional to saying unless justified objectively? It doesn't. But because there is that echo there, it may be that that was an imprecise way. I don't know if that's right or not. I just say that, as my lady pointed out, there is this wording of only if, which does attach to, we say that does reflect what's in the directive. It's not necessary anyway, because the courts have looked at the directive and looked at that language and applied it purposefully. But it's not like there is no echo of that in the regulation on my submission. So, at paragraph 6, coming back to McMenemy, the court says that it was common ground between the parties that the foregoing cases established the proper approach to construction of the legislation. It was not suggested that 2000 regulations went further than the directive in conferring protection on part-time workers or intended to do more than bring the UK law into line with the community law. That's the point that my Lord or Justice Bean has picked up. I'll come back to deal with that.
Yes.
Where the parties disagreed was over the implications of the inclusion of the word solely in clause 4.1 of the directive. In our opinion, the language of clause 4.1 of the directive connotes the need to consider whether there is a causative connection between the discrimination complained of by the worker and the part-time nature of the worker's employment. As we have said, the prohibition is against less favourable treatment of part-time workers than comparable full-time workers for the reason that they work part-time and for that reason alone. Now it continues then to talk about that necessitates inquiry into the employer's intention in so treating the part-time worker. It gives it. I'm going to come on to talk about that in my second heading. But what we say first of all is that the court here is carefully considering and paying regard to that language of solely in the directive, and it is applying that deliberately in how it construes the regulations. The court then refers to Whipple and Peake, in which the Court of Justice noted, without comment, the solely language. I accept what my learned friend says about that that was not a point in issue in Whipple, but we do see in Whipple the court refers to the directive providing for that sole criterion without comment. So the court in McMenemy had regard to the nature of the scheme of the directive as a cross-check and noted that, in its view, that accorded both with the lack of indirect discrimination protection and the ability to objectively justify. I'll come on to address those under my fourth heading. So moving then to the wording and the purpose of the directive. As we have seen, the directive effectively enacts the framework agreement agreed by the social partners. And what I say is that that is a measure, that framework agreement, of limited scope and effect, following extensive negotiations. If we can take up the directive, and that's at page 443 of the authorities bundle, and I invite the court's attention to recital 8. Recital 8 provides that whereas the general cross-industry organisations, so there are two employer federations, one public sector and one public sector, UNICE and CEP, and the European Trade Union Confederation. Whereas they had informed the Commission of their joint letter of the 19th of June 1996 of their desire to initiate the procedure provided for in Article 4, they asked the Commission in a joint letter dated 12th of March 1997 for a further 3 months. So negotiations had already been ongoing for 9 months by that stage, and then they asked for a further 3-month extension. So a negotiation period that was taking at least a year. Now, my learned friend has accepted that there is little assistance to be gained substantively from the European case law, and I agree with that submission. But it had been suggested that the directive articulates a principle of European social law that cannot be interpreted restrictively. But what I will submit is that the measure is itself limited by its scope, and it is in many ways not at all like measures which have been agreed at the community level to deal with discrimination on grounds of a protected characteristic. So we need to ask first, why was the directive made as a framework agreement? And can I refer in this regard to paragraph 27 of my skeleton argument? For ease of reference, the court can take up that. I refer there to certain propositions identified by Professor Mark Jeffrey in an article in the Industrial Law Journal of 1998 titled "Not Really Going to Work of the Directive on Part-Time Work, Atypical Work and Attempts to Regulate It." And one sees there from 27A that 9 draft directives on atypical work were put forward by the European Commission between 1982 and 1990. But only one relatively modest proposal extending health and safety regulations to temporary workers was adopted. Now, if I can ask the court to turn up the House of Commons paper, which is in the authorities bundle at the final tab, page 492. This is a research paper 00/50 of May 2000, and on the face of it, on 492, it says, "This paper describes the background to and the provisions of the part-time workers' prevention of less favourable treatment regulations," so these regulations, "and discusses other aspects of the law on part-time work. These regulations are usually debated in the 3rd Delegated Legislation Standing Committee on 18th of May 2000. So if one then turns forward in this document to page 498, one can see reflected there what Professor Jeffrey had stated in his article. The European Commission first issued a draft directive designed to give equal rights to part-timers in 1990. These proposals and subsequent revisions were always blocked by the UK's Conservative government. So in December 1994, the Commission decided to take these forward under the social chapter procedures, which at that time excluded the UK. One method of legislating under the social chapter involves the negotiation of a framework agreement between the European social partners. This method was used to negotiate the Parental Leave Directive and was used again for the part-time work proposals. So there was limited consensus in this area between member states, and it was for that reason that it was put to the social partners.
Plenty of consensus, except for the UK.
Well, in fact, some of the previous attempts had also encountered opposition from other member states, although my lord is certainly right to suggest that the greatest opponent was the UK, and indeed that perhaps reflects ideologically the greater alignment of the Conservative Party with business interests. So in a sense it's not disconnected from where one goes, with the framework agreement ending up being put to organised employer bodies and organised labour to see if they can hash out an agreement.
Yes.
So it's actually somewhat instructive to have a look in a bit more detail at the Professor Jeffrey article. And if I could ask the court to turn to page 457. This addresses the point that my Lord Justice was just making to me. So looking at 457, the first paragraph on that page, the 5 draft directives which concerned part-time work differed in respect of their content and emphasis, but the various sets of proposed requirements were all more precise, all were wider in scope, all included social security, and all either admitted no exceptions at all, or allowed for only one minor exception to the general rules to be established. This leads on to more political questions. The scope of the proposals for European-level legislation was significantly weakened in 1994 when the German presidency of the Union made a concerted effort to come up with a new draft directive which could overcome all the objections of the various member states, not least, but not only, the opposition of the British Conservative government. It was only then that a general principle of non-discrimination was introduced to replace the specific requirements, and that the scope was narrowed and social security dropped. The resulting proposal was reluctantly accepted by the Commission, and we see the quote there as representing, in the words of the Commissioner, the minimum of the minimum, below which nothing is conceivable in social protection. But even that minimum of the minimum attempt failed, as one sees in the next paragraph, and the Commission then decided to make use of the procedures under the Protocol and the Agreement on Social Policy to put it to the social partners. It stressed at that point that the German minimum of the minimum proposal would not be the starting point. But when one looks over the page, starting at the bottom of 457, the professor then notes, this then begs the question as to why just 3 years later the Commission was prepared to accept an agreement between the social partners which was limited to part-time work only and which appears to offer even less than the minimum of the minimum proposal of 1994. So the reason that's posited there, reading down that page, as to why the Commission was prepared to accept that very limited proposal that one sees in this directive, is because the Commission and the European Trade Union Confederation wanted to show that the social dialogue policy mechanism was a success for the forthcoming European Council Amsterdam meeting. So, over on 459, one then sees that there were attempts made, first of all by the Commission, to then increase the scope of the directive. Sorry, first of all by the Parliament to increase the scope of the directive. And also by the Commission. So looking at 459, first of all one sees at the bottom of 458, the Commission took great care not to depart from the exact text of the agreement, so not to depart from the exact text of the framework agreement agreed by the social partners. As we have seen, it preserved the text in full as a separate annex to the directive. It also made it clear that it would withdraw the proposed directive were the Council not to accept it in its entirety. Nonetheless, the Commission did attempt to add some further requirements aimed at tightening up Clause 6 and ensure the creation of effective sanctions for non-compliance. If one looks then to the end of that paragraph, it says the Commission rejected the Parliament's proposals to make further amendments on the grounds that this was too great an interference with the autonomy of the social partners. But then the Commission had its own proposals deleted by the Council. So the result is that the directive does no more than give legal effect to the unamended framework agreement between the social partners. Now, if one then looks from that at the directive itself, at page 44, starting at 444, but looking at 443, one sees there in Article 1 the stated purpose, which is the purpose of this directive is to implement the framework agreement on part-time work concluded on 6th of June 1997 between social partners. And we also, in my submission, see echoes of the limited nature of the intervention which was sought to be made, and perhaps hints of the compromises in negotiations that were behind it throughout the terms of the directive as well. If one looks back at the recitals, first of all, one sees in recital 2, this is page 443, that management and labour requested jointly that the agreements at the community level be implemented. Then at recital 10, whereas the Council asked management and labour to make use of the opportunities in concluding agreements since they are, as a rule, closer to the social reality and to social problems, i.e. this hadn't been possible to agree it at governmental level, but perhaps the social partners might be able to thrash it out between organised labour and employers' groups. Then at recital 11, the social partners wish to conclude an agreement on part-time work setting out the general principles and minimum requirements for part-time working. Then, over the page, one sees the intention to do that. This is the end of recital 11, on a basis which is acceptable for employers and workers alike. Moving forward then to recital 18, that notes that the Commission had drafted the directive in a way which complied with Article 2.2 of the Framework Agreement. The directives in the social policy domain shall avoid imposing administrative, financial and legal constraints in a way which would hold back the creation and development of small and medium-sized enterprises. And of course that is a particularly relevant consideration when one looks at providing some protection to part-time workers, because part-time workers are a particular feature, often, of small businesses.
I'm so sorry, which paragraph is that?
So that is in recital 18.
18, sorry, it's my fault.
So I was just highlighting there at the end, the Commission drafted its proposal for a directive in compliance with Article 2.2 of the Agreement, which provides that the directives in the social policy domain shall avoid imposing administrative, financial and legal constraints in a way which would hold back the creation and development of small and medium-sized undertakings. And then one can see Article 2.2 at page 447 in the Framework Agreement itself. It just says the same thing. Now, looking then at the Framework Agreement, if one sees at paragraph 2 of the Framework Agreement, in the preamble, paragraph 2 of the preamble, this is page 446, there is express acknowledgement in that paragraph of the diversity of situations in member states, and acknowledging that part-time work is a feature of employment in certain sectors and activities. This agreement sets out the general principles and minimum requirements relating to part-time work. It illustrates the willingness of the social partners to establish a general framework for the elimination of discrimination against part-time workers and to assist in the development of opportunities for part-time working. The Framework Agreement repeats that reference to on a basis acceptable to employers and workers. So if one then looks at paragraph 29 of My Skills and Argument, I refer there to the EAT's decision below at paragraph 72. The reference there to 71 is a mistake. That should be to paragraph 72. And that's at page 58 of the core bundle. So what the EAT said at paragraph 72 is that its approach to the proper scope of the regulations is to construe them to make them broader in application. One sees in the middle of that paragraph, they say, having regard to our collective practical experience of issues relating to part-time work, we are mindful that discrimination against part-timers will often take place because of factors associated with their part-time status. Limiting protection to less favourable treatment solely on the ground of part-time work risks excluding such cases where the part-time nature of the work might be the effective but not the sole reason for the treatment. That would seem counter to the purpose of the Framework Agreement. We share the view expressed by the EAT and Sharma. They say, even if we're wrong about that, we cannot see why the minimum requirement should limit a wider protection allowed under domestic law. Now, the decision of the EAT in Sharma was a decision reached in circumstances where only one of the parties before the EAT was legally represented. It's also a decision which, in my submission, must be treated as per incuriam. One looks at the reasoning of the EAT below accepts that it ought to follow McMenemy. that reflects, as my learned friend has conceded, the appropriate approach applying to answer, and therefore had McMenemy been cited to the EAT in Sharma, like the EAT below, it would have been bound to follow it. Now, I'm going to address the reasoning at paragraphs 47 to 50 of Sharma. I say that the examples there simply don't work, and I'll come back to that. So the force of the President Elias's reasoning there is limited. But again, that assertion of purpose being posited both by the EAT in Sharma and by the EAT below in this case, in my submission is not borne out by the limited terms of the legislative intervention reflected in the directive. Now, it may, in addition on this submission, be worth looking back at the House of Commons paper at page 492. If I could ask the court to turn to page 494. One sees there the third paragraph up from the bottom. The paragraph starting, there are over 6 million.
Yes.
There are over 6 million part-time employees in Great Britain, of whom about 1 million have a comparable full-time employee. So, because of the requirement in the directive and in the regulations for an actual rather than a mere hypothetical comparator, only 1 million of the 6 million part-time workers are within scope of the regulations. And I set out in paragraph 28, I don't propose to go there, my skeleton argument, the references made in contemporaneous articles by academics at that time, noting that therefore the clear majority, the vast majority of part-time workers would not benefit from the regulations. When the consultation on the draft PTWRs was launched, and if I can take the court forward to page 507, one can see at 506 the heading Consultation on Draft Regulations. And then if one goes over to 507, towards the top of the page, it says, the press notice quoted Stephen Byers, the Secretary of State for Trade and Industry, as saying, and I draw attention to the second paragraph quoted, we want to establish a minimum standard of fairness for part-timers, so that no longer will they be treated less favourably than the full-timers they work alongside. So, seeking to establish minimum standards of fairness, reflective of what the directive sought to do. Then, if one turns forward to page 509, this is the consultation on the draft regulations. Sorry, 509. Yes, just before the heading E, it notes that the regulatory impact assessment of the proposed regulations estimated that 45,000 of the 6 million part-time workers could directly benefit from the new law through increases in pay and non-wage benefits. And the financial value of that improvement was put at 10.7 million per year, and the overall compliance cost for employers at 14.7 million.
That's an even smaller number of the part-time employees who could benefit.
Yes. So what then happens is that there is a process of consultation. At that stage, the proposal was only to apply the regulations to employees, but there was a lot of criticism from that, especially from the trade union movement. And so subsequently what happened was the definition of applicable worker was extended to include workers as well as employees. And so one sees, if one looks forward at 517, my lady, that after that category of relevant persons had been expanded in that way, the revised regulatory impact assessments, is the middle of page 517, increased the number of part-time workers expected to benefit to 400,000, and also increased the overall compliance costs from 14.7 million to 27.4 million. Now, if one goes back to 494, one can see at the bottom there the observation that about 78% of part-time employees are women. And of course, the great part of the impetus behind doing anything in this area was to improve the position of women. And a key aim was to secure a right to request part-time working on return from maternity leave. That was a proposal which the government did not decide to bring forward. And if I can just take the court to my skeleton argument, at paragraph 28, there is a detailed discussion in the article of Professor Eileen McColgan as to the impact, this is a contemporaneous article of 2000, as to the impact these regulations would have. And if one looks at paragraph D of my skeleton argument, I quote there the observation of the Select Committee that if the directive is transposed in its basic form, it will be no more effective and in some areas less effective than existing legislation. What one sees in those articles is a recognition that indirect sex discrimination claims are likely to provide a greater practical recourse for women who consider that on account of matters connected to their part-time status, they are being treated unfairly than these regulations implementing this directive. Nowhere in the whole of this very detailed and thorough House of Commons paper, research paper, is there any suggestion that the government was seeking to go further in the regulations as a matter of causation than the directive? So
is there any discussion about that question at all?
No discussion at all. No. Now, the way in which the regulations operate is, in my submission, much different to and much more limited than other relevant equality legislation. So if one turns up the regulations at page 411 in the authorities bundle, and then turns forward first to page 417, one sees there in 5.1 that the right not to be treated less favourably is not to be treated less favourably than a comparable full-time worker. So one has to look back at regulation 2.1 on page 413.
And that means a real one, doesn't it? Not
But it does mean that, my lord. It means more than that as well. So if one looks at regulation 2.4, first of all, it requires that, this is 4A1, both workers are employed by the same employer under the same type of contract. So if one looks up the page at regulation 2.3, one can see that those different types of contract are identified. Employees are employed under a contract that is not a contract of apprenticeship. Employees employed under a contract that is a contract of apprenticeship. Workers who are not employees. So one cannot say, I, a part-time apprentice, compare myself to a full-time employee. Or one can't say, I, a part-time worker, compare myself to a full-time employee. They must be employed under the same type of contract. that already has a limiting effect. If one imagines a situation of some casual workers who are not employees, one could imagine a situation in which they may consider that they ought to be treated in the same way as employees, so that's not permitted. They can only compare themselves against an equivalent worker, not an employee. Secondly, under 4A2, they must be engaged in the same or broadly similar work, having regard, where relevant, to whether they have a similar level of qualification, skills, and experience. I pause here to say that that, again, is a potentially quite broad limitation, because if one imagines somebody who has been working part-time, say 1 or 2 days a week, for a period of years, as against a full-time worker who's been working 5 days a week for that same period, that might raise an argument as to whether they have a similar level of experience. And finally, one sees at 4AB, the full-time worker works or is based at the same establishment as the part-time worker, or where there is no full-time worker working or based at that establishment who satisfies the requirements of subparagraph A, works or is so based at a different establishment and satisfies those requirements. One also then needs to look at regulation 5.4, this is forward on page 417. This is on the less favorable treatment of part-time workers, and one sees there at regulation 5.4, a part-time worker paid at a lower rate for overtime worked by him in a period than a comparable full-time worker is or would be paid for overtime worked by him in the same period shall not, for that reason, be regarded as treated less favourably than the comparable full-time worker, where, or to the extent that the total number of hours worked by the part-time worker in that period does not exceed the number of hours the comparable full-time worker is required to work in that period. So if you,
So very limited protection in respect of overtime.
yes, so if you, a part-time worker, are working 20 hours and the full-time workers are working 35 hours, you're not entitled to any overtime pay unless you exceed the 35 hours of the full-time worker. And interestingly, that is actually at variance with what the Court of Justice has found in a post-Brexit decision to be the position under the Part-Time Working Directive. If one looks in the authorities bundle, that's an authority that my learned friend introduced, but ultimately didn't find it necessary to refer to. This is the decision of IK at page 379. And if one looks at head note 7, it states there, under case law, the remuneration of part-time workers must be equivalent to that of full-time workers, subject to application of the principles pro rata temporis, as provided for in clause 4.2 of the Framework Agreement. Consequently, for part-time workers, if the number of hours of work in excess of which they received additional pay was not reduced pro rata temporis in step with the duration of employment agreed in their employment contracts, it appeared that those workers were treated less favourably than full-time workers, which is prohibited by clause 4.1 of the Framework Agreement, and less objectively justified. Now, obviously, that's a decision of the CJAU post-Brexit and a long time after the implementation of the regulations, but it illustrates that some of the provisions which have been seen fit to be enacted in the regulations have a more limited protective purpose, even when pertains under the directive. Additionally, at 4.2.1, it's not necessary to turn up there, but there is no ability to seek injury to feelings compensation for part-time work discrimination in the same way that there is in claims of discrimination on grounds of protected characteristic. And I say that that is a particularly telling example because it identifies that part-time worker status is not in many relevant ways to be equated to a protected characteristic. Can I go on then to just deal and sweep up with the reasoning of Mr. Justice Elias in Sharma
Yes.
at paragraphs 47 to 50? So if one takes up Authorities Bundle tab 8, page 168. I address these in my skeleton argument at 31 and 32, but just to put the point simply, at paragraph 49, in support of the broader approach, which, without the benefit of citation of McMenemy, Mr. Justice Elias felt was appropriate, he says, to take a simple example, if the employer decided to discriminate against all part-timers over the age of 30, it could be said that there were two reasons for the discrimination, being a part-timer and being of a certain age. But of course, in that case, the employee or the worker is able to rely upon a claim in age discrimination. Similarly, if there were two reasons, one was on account of their sex, and another was on account of their part-time status, they could rely upon a claim in sex discrimination. A claim in sex discrimination could also be raised not only as a matter of direct discrimination, but as a matter of indirect discrimination. So that example, I say, doesn't take matters any further. The second example in paragraph 49 is an example if the employer deliberately discriminates against all his part-timers in factory A, but not those with identical full-time comparators in factory B. Can it really be said that because only some part-timers are selected for the less favourable treatment, the directive and by extension the regulations are not intended to be applicable? But as we saw in the regulations a moment ago, the comparable full-time worker is a worker who is working at the same establishment. So if in factory A, in one part of the country, there was a difference between the part-time workers and the full-time workers, the appropriate comparison is to the full-time worker in that factory, not another factory. So again, in my submission, that example doesn't work. This then takes me on to the second of my 5 themes, which is that in the decision of the EAT below, in the decision of the EAT in Sharma, and in my learned friend's submissions, there is an attempt to borrow and analogize by reference to other areas of domestic discrimination law. And in my submission, it is not principled to borrow from those other sources in circumstances where they deal with very different matters, discrimination on grounds of protected characteristics, as opposed to discrimination as governed by the regulations implementing the part-time work directive on grounds of part-time status. So can I take the court first of all to the EAT's judgment below? This is in the core bundle at page 57.
Yes.
Page 57, and it's paragraph 69. So the middle of the paragraph, it says, thus, if the regulations introduced pursuant to the broad enabling power conferred by section 19 of the Employment Relations Act 1999, which make no reference to the PTWD, provides for a wider approach to the question of causation than that specified under clause 4.1 of the Framework Agreement, we do not consider there is any requirement to reduce that protection. But that begs the question that it posits. The part-time worker regulations do not expressly provide for a wider approach. What the EAT is doing is saying that it should borrow from other domestic law to inform the content of on the ground that, rather than look to construe as it accepted it should at paragraph 68, as far as possible consistently with what the directive provides. The EAT below, the respondent was unrepresented.
Yes.
So the EAT had the benefit of argument from my learned friend, but not from the respondent legally represented. And I say that it is an unfounded assumption. I'll come on to show you why I say that. To read across these principles from other provisions to the proper construction of the regulations. Now, can I take you then to the EAT's judgment at paragraph 36? This is at page 48. So at paragraph 36, it starts on page 47, summarising the claimant's case.
Yes.
If one looks at the bottom of page 47, one can see it's a rather long sentence, but it's referring to the arguments that McMenemy is not consistent with the purpose of construction of the regulations, because the directive made clear the framework agreement sets minimum standards, not required by principles of construction, not the approach adopted by the EAT in Sharma or Carl, when the test had been said to be one of effective cause, consistent with the approach to causation in other analogous statutes. And again, I don't accept that these are relevantly analogous statutes. The part-time worker regulations are not analogous to the Sex Discrimination Act, the Race Relations Act, or the Equality Act. And indeed, at paragraph 39 of the EAT's decision, paragraph 27 of the EAT's decision, on page 44, the EAT recognises, this is the start of paragraph 27, that there is not a precise read across from the protection afforded under the Equality Act to that provided by Regulation 5 of the Part-Time Worker Regulation. What the court goes on to say is, on the other hand, the basic principle is the same. The protection is against less favourable treatment of one worker with a specified characteristic, here being a part-time worker, as compared to another who does not have that characteristic, someone who works full-time. I submit that that's wrong, that the basic principle is not the same. Can I ask the court to look next at the part-time worker directive? At page 444. Can I draw the court's attention to recital 23? Recital 23 notes, whereas the Community Charter of the Fundamental Social Rights of Workers recognises the importance of the fight against all forms of discrimination, especially based on sex, colour, race, opinion and creed. And that's an uncontroversial proposition one sees repeated frequently in European case law and in domestic case law, the special status of protected characteristics and the particular importance as a matter of social policy of eliminating discrimination on the basis of protected characteristics. In this case itself, in the ET, in this case, the present case, the claimant sought to amend to introduce claims of race and or sex discrimination. And that was refused. One can see this, perhaps not necessarily turn it up, but for your note at page 74 of the core bundle. That was refused by the Employment Tribunal, implying the Sell-Kent bus principles as too late. Yeah. And they said the application to amend would amount to a relabelling of existing allegations. It raised a wholly new matter under a different piece of legislation. So, if one looks then at the EAT's decision, at paragraph 64, so this is page 55, one can see there at paragraph 64 that the EAT referred to the similarity between the wording "on the ground that" in the regulations and, first of all, the wording "on the ground of" under the Legacy Sex Discrimination Act 1975, and then secondly, "on the ground that" as a standard part of the test applied in detriment cases under the ERA 1996 in cases of whistleblower protections. Then at paragraph 65 to 66, it refers to the reasoning in O'Neill in the EAT and in Betchett in the Court of Appeal. I'm going to address each of those in turn, but what I say again is that just because the language is similar only takes matters so far. It was accepted that the regulations needed to be construed by reference to the directive, which brings into consideration other factors and other language, the solely because language. The SDA 1975 and the ERA 1996 are not to be interpreted by reference to this or equivalent European legislation making reference to the word solely. So if I can then address O'Neill, this is addressed by the EAT at paragraph 65. It was a case under the Sex Discrimination Act, and in which the Industrial Tribunal had considered the dismissal of a pregnant teacher under that act. It had applied European case law and noted the special position of pregnant women in employment, attracting special protection, and noted that a dismissal on the grounds of pregnancy is a dismissal on the grounds of sex. It then referred on page, so if we take this up in the authorities bundle at 75.
Sorry, page.
Sorry, so I'm just going to actually turn up O'Neill itself. So,
Oh, right.
the
Yes.
first bit I wanted
Quite
to
early on, isn't it?
page 75 in the authorities.
I'm so sorry for sneezing at an inopportune moment.
Yes.
So one sees there on pages 75 to 76 that there is reference to the James and Eastleigh decision. That's at page, using the case's internal numbering, 43 D. To say that it is established that the test of direct discrimination on grounds of sex is not one of subjective mental processes, i.e. their intentions, motives, beliefs, or subjective purposes, but an objective test of causal connection. This is the middle of C to D.
Yes.
It continues to note that the tribunal was correct to first ask what the reason for the dismissal of the claimant was, and also correct to say if the sole reason was that she was pregnant, that was direct discrimination. That was also correct, but not a complete statement of the law. And it asked then about motives, and noted that the reputational impact of an RE teacher being pregnant from a Catholic priest, when publicly known, was given and relied upon by the respondent as its motive. One then turns forward to page 80 in this decision. Looking at B on page 47, the court said, the Sex Discrimination Act 1975 requires the Industrial Tribunal to decide a case of sex discrimination by having regard to the question whether the treatment complained of was on the ground of sex, not by having regard to the subjective motives of the alleged discriminator. Consideration of motives is to be avoided. Then continues, dismissal for pregnancy is a ground of sex. Pregnancy is unique to the female sex. The concept of pregnancy per se is misleading because it suggests pregnancy as a sole ground of dismissal. Pregnancy always has surrounding circumstances, some arising prior to the state of pregnancy, some accompanying it, some consequential on it. The critical question is whether, on an objective consideration of all the surrounding circumstances, the dismissal or other treatment complained of by the applicant is on the ground of pregnancy. It need not be only on that ground. It need not even be mainly on that ground. Thus, the fact that the employer's ground for dismissal is that the pregnant woman will be unavailable for work because of her pregnancy does not make it any less a dismissal on the grounds of pregnancy. So, in fact, the other factors in the circumstances surrounding the pregnancy relied upon as the dominant motive were all causally related to the fact that the applicant was pregnant. So one can see there the very pressing social reasons going back to the special status of pregnancy, special status of pregnancy and sex discrimination, why it would have been insufficiently protective to allow arguments to be run on the basis that one has to look only to the sole cause. And the court is establishing there in a multiple cause case that it is sufficient if there is an effective cause of the treatment that relates to the protected characteristic. So then one has fetches, which is addressed at paragraph 66 by the EAT. So going back to the EAT's decision. And one sees there in paragraph 66, it's easier to take this in the EAT's decision below. The middle of paragraph 66, the EAT noted, in explaining his reasoning in Fetchit, Lord Justice Elias acknowledged that the whistleblowing protection under section 47B was not derived from EU law, but nevertheless continued. However, the reasoning which has informed the EU analysis is that unlawful discriminatory considerations should not be tolerated, and ought not to have any influence on an employer's decisions. In my judgment, the principle is equally applicable where the objective is to protect whistleblowers, particularly given the public interest in ensuring that they are not discouraged from coming forward to highlight potential wrongdoing. So, emphasising there that discriminatory considerations in that context should not be tolerated and should not have any influence. What I say in relation to that is that the same strong public interest does not apply in the same way to part-time worker status as it does to whistleblowing protection and to sex discrimination. One can imagine a situation in which there may be some mixed reasons and that is not sought to be captured by the limited intervention that the social partners have agreed upon. There are also other ways in which the directive sets out a divergent approach as between part-time worker discrimination provisions and protected characteristic discrimination protections. I've referred to the fact that under clause 2 of the framework agreement, members may exclude wholly or partly from the scope of the agreement part-time workers who work on a casual basis. So it permits casual basis workers to be removed from the scope of the protection of the directive. And if one looks in the authorities bundle at 448, in the directive itself. One sees there at clause 6, paragraph 4, that this agreement in the framework agreement, this is the framework agreement.
Yes.
This agreement shall be without prejudice to any more specific community provisions, and in particular, community provisions concerning equal treatment or opportunities for men and women. Now, if I can take the court back to the House of Commons explanatory paper at 509, one sees here the description of what happened in the Education and Employment Select Committee. And what's explained underneath heading E on page 509 is that the Select Committee had published a report on part-time working and contained a number of recommendations about the implementation of the directive, and that the text in bold is the Select Committee's recommendations and the text beneath it is the government's responses. So if one can then look forward to page 510 and the heading, the concept of a hypothetical comparator.
Well, and I was caught by paragraph 21. Insofar as either this research paper or the committee's report is a helpful aid to construction, the committee were expressing some strong views at paragraph 21.
So paragraph 21 in bold is the Select Committee report.
Yes.
And then below that is the response of the government. Then if one looks at 24 under the concept of a hypothetical comparator, the Select Committee recommends that within the legislation, the definition of a comparator should be a full-time worker with the same employer or in the same service, but where a primary fact gives cause to a tribunal to draw an inference that there had been unlawful discrimination, the use of a hypothetical comparator should be acceptable. And the government states below, the government notes the committee's recommendation and that this would be in line with existing discrimination law.
And then it talks about a consultation.
But what one also sees then, if one looks forward at 513, so 513 is under the heading on the bottom of 512, other responses to the consultation. In the middle of the first bullet point, one sees the Equal Opportunities Commission pointed out that the Sex Discrimination Act applies to a broader group of people in employment. And then the next bullet point, part-timers should be allowed to compare their job with a hypothetical comparator. Under the proposed regulations, they will only be able to compare their jobs with a full-timer doing the same job for the same employer. This means that millions of part-time workers doing jobs only done by part-timers, such as catering and cleaning, will not benefit. The Equal Opportunities Commission pointed out that the proposed definition of a comparator differs from that of the SCA and the Equal Pay Act. Some part-time workers would be able to use this legislation, but not the regulations. But then in the final regulations as enacted, these suggestions were not taken on board, and a hypothetical comparator remains unavailable under the regulations. One sees at 514 after the first main paragraph without a bullet point, it says, employers' organisations were pleased that, the end of the sentence, there was no provision for hypothetical comparators. So as one had seen in the negotiation of the framework agreement, similarly in the consultation on the implementation of the regulations, there was a push-pull going on as to how broadly or narrowly framed the measure should be.
And are you saying that the solely topic never came up?
It doesn't appear to. There's no reference to it.
No, that's fair enough.
But what I seek to draw from this is that where one says, look at the approach in whistleblowing, look at the approach in sex discrimination, one must borrow from that, because the purpose must be this broad, expansive, protective purpose. That simply doesn't reflect the much more limited.
The case, the heart of the case you have to meet, surely, the reason why Mr. Jones relies on some other areas of employment discrimination law is the use of the phrase on the ground that or on the ground of.
Yes, my lord. And I think that what Lord Justice Elias says in Fetch It is that, of course, one has to look at the language. The language has to be construed, and there's difference in all of these different statutes, even the small differences between the Sex Discrimination Act. But he says that it's appropriate to borrow from anti-discrimination law, sex discrimination, and apply that to whistleblowing because it serves the same reasons, or having a strong protective purpose. That means it ought to be construed broadly. What I say is that one can put protected characteristics and whistleblowing in one category. The protected characteristics draw on the European approach to that language and to construing that in a broad, purposive way. And the court in Fetch It says, well, I accept that there are different statutory routes and that one doesn't derive from the same source as the protected characteristics, but the same principle ought to apply. What I say is that there's no reason in principle why the same reasoning should apply in this case to language, especially when it is qualified expressly in the directive by the language of solely. So where that takes me then is to this point about intention. And in my submission, that is something of a red herring. The Employment Tribunal below, the Employment Appeals Tribunal below, has dismissed ground 2, but has criticised the reasoning in relation to intention. But it said that even taking that into account, it can't conclude that the ET would have reached a decision on the basis of the sole criterion. I'm going to take you through the cases in relation to this. And can I start by looking at paragraph 43 at page 50 of the decision below?
Yes.
So there, at paragraph 43, the President of the EAT said, in determining the reason for the treatment in issue, in circumstances in which the discriminatory reason is not inherent in that treatment, it will be necessary to have regard to the mental processes of the relevant decision maker, although a distinction should still be made between motive and reason, as President Underhill observed in Amnesty International. The subject of the inquiry is the ground or the reason for the putative discriminator's action, not his motive. A benign motive is irrelevant. We agree with that. Look at the reason. And we say that that is what the ET did in this case. It's what the Court of Session did in McMenemy. Now, what the appellant says about this in his skeleton argument, my learned friend says about this in his skeleton argument, is he says, first of all, at paragraph 30.1, that the focus in Gibson on intention is a feature of its time, and it's well established, in particular following JFS, that intention is not a necessary part of the test in race or sex discrimination cases, and nor should it be in the part-time worker context. And then secondly, at paragraph 50, he says that the Court of Session's reasoning in McMenemy, following and applying Gibson, is that it is necessary to examine the respondent's intention, and that part of the reasoning cannot survive contact with JFS in the Supreme Court. And that the Court of Session's intention reasoning is intricately wrapped up with the sole ground reasoning, seeing these as interlinked. Now, in a moment I'm going to hand up Amnesty and take that as a sort of starting point for relevant principles, but in summary, what I'm going to say is as follows. First of all, we say there's no error in McMenemy, which emphasised the reason and noted that it was not concerned with motive. Secondly, in cases where the discriminatory reason is not inherent in the treatment, and I say that this is one of those cases, it may well be, often is necessary to consider the mental processes of the decision maker.
Just slow down a bit if you want.
Yes.
If you want us to write this down. So, right. 1, McMenemy not concerned with motive. 2.
Yes, so McMenemy was looking at reason, correct?
Yes.
Not concerned with motive. 2. In cases where the discriminatory reason is not inherent in the treatment, it is necessary to consider the mental processes of the decision maker. That's what amnesty I just cited says, and that's what McMenemy and the ET below did. JFS, third point, was a race discrimination case in which the discriminatory reason was inherent in the treatment. So the school was giving priority to children when oversubscribed based on a test of matrilineal descent, whereby a child was only regarded as Jewish if his mother was Jewish by birth or conversion. That was a test of ethnic origin. So in JFS, the court said the fact that your motive may be religious, not racial, is irrelevant to the ground. So that is a James type inherent or criterion case. So that's a category 1 case. So in JFS, the criteria for admission to the school is on grounds of ethnic origin. In James, one could have reframed the rule as to pricing for the swimming pool. If you are a man and you are 62, you must pay this. If you are a woman and is 62, you will not pay anything. As my lady said earlier, as a proxy. Amnesty itself was also a James type case. In Amnesty, a worker was not sent to a particular region, and it was said that her race would make it unsafe to send her there. Again, that was considered to be inherent in the criterion. The present case is a second type of case. It's the Nagarajan type, in which the provision itself is not, on its face, inherently discriminatory. So the classic example of an inherently discriminatory provision might be a hotel that has a sign that says, no blacks. One doesn't have to go into the mental processes because it's inherent in the criterion itself. But in this case, and in the Nagarajan type of cases, I think that my learned friend and I agreed on all of this. One does need to look at why. So we say in this case, my learned friend gave the example, well, I wasn't promoted. But why? What is the reason why?
So just to be clear, and so that we're not at cross purposes, I do agree with all the legal propositions which have just been put forward to you under this broad heading of JFS and amnesty. When my learned friend is saying, in this case, if he means literally this case that we're arguing about, no, of course, my position has been that it would be an inherent discriminatory case.
Yes.
I'm grateful.
And that's because it doesn't really matter why the decision maker required all the drivers to pay the same circuit fee. The fact is that he did,
Yes.
and that is discriminatory.
Yes.
So what I say in relation to that is that this is not an inherent case, because there is nothing to do with the criterion that relates to part-time status. It is, if you wish to be a driver for us, you must pay the circuit fee to access our technology. And that applies to everybody. It is not like a hotel putting up a sign saying, no black guests welcome.
Of course it's not, but that example is so far removed. In the present case, it's not very helpful.
Well, I think this area is replete with, there are different ways of looking at some of the same things, and questions of categorization are sometimes difficult around the edges. But certainly if one said, imagine a situation where you say, there are no part-time drivers, everyone is a full-time driver and you have to pay a circuit fee. It would seem odd to say that it was inherent in that provision that it related to part-time status. What I then go on to say is that if one looks at amnesty, when you look at the processes, what is behind the decision, the reason why, in a case where it is not inherent in the criterion, then what the courts have deprecated is looking at motive. But they have accepted there are different ways of putting in language what one does look at. So, for example, it is legitimate to look at motivation, but it is not legitimate to look at motive. And so when one looks at the reasoning in Gibson and McMenemy, I say that one actually looks at JFS, it is motive that they are most concerned with as being erroneous, and that intention can be understood in Gibson and McMenemy as being concerned with what was the reason why. So can I now hand up the amnesty authority?
Much trailed, but at last the moment has come.
At last it arrives. It is a decision of the Employment Appeals Tribunal, a decision of Mr. Justice Underhill as president, and it has been cited in other cases subsequently, and I think it's particularly helpful in finding one's way through some of the thickets in this area. So if one can look at paragraph 31 on page 1469, Mr. Justice Underhill starts by saying that it seems that the relationship between the approaches in James and Nagarajan is regarded by some as problematic. We do not ourselves believe there is a real difficulty if attention is paid to the form of the alleged discrimination with which the House of Lords was concerned in both cases. And at 32, the basic question in a direct discrimination case is what is or are the ground or grounds for the treatment complained of. This is the language of the definitions of direct discrimination in the main statutes and various more recent employment equality regulations. 33. In some cases, the ground or the reason for the treatment complained of is inherent in the act itself. If an owner of premises puts up a sign saying no blacks admitted, race is necessarily the ground on which or the reason why a black person is excluded. James and Eastleigh is a case of this kind. There is a superficial complication in that the rule which was claimed to be unlawful, namely that pensioners were entitled to free entry to the swimming pool, was not explicitly discriminatory, but it nevertheless necessarily discriminated against men because men and women had different pensionable ages. The rule could entirely accurately have been stated as free entry for women at 60 and men at 65. The council was therefore applying a criterion which was of its nature discriminatory, was gender-based. In cases of this kind, what was going on inside the head of the putative discriminator, whether described as his intention, his motive, his reason, or his purpose, will be irrelevant. The ground of his action being inherent in the act itself, no further inquiry is needed. So that, I think, picks up on what my lord is saying, that there are different degrees of examples. Some of them are clearer than others. So in James, it requires a little bit of unpacking.
The no blacks admitted. I hadn't realised it was Lord Justice Underhill's idea, not yours. It still seems to me rather unhelpful. But anyway, it leads into James, which of course is a famous case.
Then at 34, but this is not the only kind of case. In other cases, of which Nagajaran is an example, the act complained of is not in itself discriminatory. It is rendered so by discriminatory motivation, i.e. by the mental processes which led the putative discriminator to do the act. Establishing what those processes were is not always an easy inquiry, but tribunals are trusted to be able to draw appropriate inferences. Even in such a case, it is important to bear in mind that the subject of the inquiry is the ground of or reason for the action, not his motive. Just as much as in the case of James, a benign motive is irrelevant. This is the point being made in the second paragraph of the passage which we've quoted in the speech of Lord Nichols in Nagarajan. The distinctions may seem subtle, but they are real, as the example given by Lord Nichols at the end of that paragraph makes clear. And then he goes on at 35 to talk about Lord Gough's speech in James and Eastleigh. Characterise them as, on the one hand, cases where there is a gender-based criterion. So that's why sometimes the inherent category is referred to as the criterion category. And in other cases where the complainant's sex is the reason why the defendant acted as he did. I think that, and my learned friend and I agree, is JFS, is that there is a unitary test of reason why, but reason why may need to be answered in different ways if it's a James type case or a Nagajaran type case. So if one looks at paragraph 36, as the court says here, there is no difficulty in reconciling James and Nagajaran. The ultimate question is necessarily what was the ground of the treatment complained of, or the reason why it occurred. The difference between them simply reflects the ways in which the conduct may be discriminatory. Then goes on to talk about the but-for test, and again I associate myself with what my learned friend has said in relation to that. The but-for test will be useful in many cases, but it can be under or over-inclusive. An example of it being not working, for example, is a case where, this was an actual case where a secretary was dismissed for having had after having had an extramarital affair with her boss. It was said, well, if one asks, is that but for sex? Well, but for her being a woman, he wouldn't have entered into a relationship with her. But that's not the reason for the dismissal. The reason was that it was actually an inappropriate workplace relationship. So one can see the but for test can be under-inclusive, can be over-inclusive. But in a sense, one can put that aside, because what's made very clear is that here in 36 and in JFS the question is reason why, and that's just looked at through a different lens in James type cases and looked at differently through a different lens in Nagajaran type cases. So turning over the page, one then sees the conclusions in relation to that, and it's probably not necessary for me to take the court through the rest of that, but it may be worth afterwards reading to the end of paragraph 38. So when one then looks back at McMenemy at page 151 in the Authorities Manual, one can see there in paragraph 3, the end of paragraph 3, the Court of Session is saying, solely does indeed mean that the less favourable treatment of part-time workers which is prohibited by the directive must be the reason that they work part-time, and for that reason alone. Correct? Then at paragraph 6, in the middle of that paragraph, in our opinion, the language of clause 4.1 connotes the need to consider whether there is a causative connection between the discrimination complained of by the worker and the part-time nature of the worker's employment. So, again, correct, looking at a causative connection, the reason why. And then at paragraph 6, where it continues, this necessitates inquiry into the employer's intention in so treating the part-time worker. One sees the first part of Gibson that's quoted says, whatever may be the motive of the employer, it is necessary to look at the intention. So Gibson, and McMenemy referring to Gibson, is expressly disavowing motive. Now, it may be that one would now put the word intention more in terms of mental processes, what is going on in the mind of the decision maker. But in my submission, there is no basis to say that it is wrong by reference to JFS and it is wrong by reference to amnesty to have referred to intention. If one looks then at the decision in this case, in the Employment Tribunal below, can I ask you to turn to page 73? paragraph 6 of the Employment Tribunal's decision, the judge notes in fourth that applying Regulation 52A, the EAT found that the reason emphasised for the treatment was the length of the shift and not the fact that the employee worked part-time. So again, looking at reason. Then if one goes forward to page 84, at paragraph 58, it is then necessary for me to decide whether such treatment is on the ground that he was a part-time worker. And at paragraph 60, in accordance with the McMenemy case, I consider the intentions of the respondent and the reasons why the claimant was charged the full circuit fee. So I say what's being referred to there is what I've just taken the court to in McMenemy. One must look to the reason, one doesn't look to the motive, and that the intention is to be understood in that sense. Then at paragraph 63, the reason why the claimant was charged a circuit fee is because this was the way in which private hire companies such as the respondent were operating. It's the way in which the respondent earned a revenue for the business. Unlike newer businesses such as Uber, the respondent did not collect the fares from its cash customers. They were paid direct to the drivers. The circuit fee gave the drivers access to the respondent's booking system. Whereas I might go so far as to accept that the claimant was charged a circuit fee because he was treated as self-employed, treatment that is found to be incorrect. That in itself does not establish causation under the regulations, because it does not show that he was charged the fee because he was working fewer hours than his fellow drivers. Then if one looks at paragraph 65, so this is on page 86. So the reference there to the Campbell, that's the Forth Valley case. The Employment Tribunal had found that the only difference between Mr. Campbell and his comparators was that he worked fewer hours. In particular, he worked a 4-hour shift rather than a 6-hour shift. As he was not paid for a rest break when working for a 4-hour shift, the Tribunal concluded there was less favourable treatment. The EAT rejected this argument. It was decided the Tribunal had not properly applied the causation test in accordance with McMenemy. It was accepted that a part-time worker would inevitably work fewer hours than a full-time comparator. However, the Tribunal could not properly conclude that there was any causal connection between Mr. Campbell's part-time status and the length of his shifts. There was no basis on which they conclude the difference in treatment was on the ground that he was a part-time worker, far less that the part-time status was the sole ground for such difference in treatment. And then in paragraph 66, one sees at the end of that paragraph, so it's perhaps just read the paragraph to yourselves. The reason why he was charged the fee was so that he could obtain access to bookings through the respondent's systems.
The objection is not to the existence of a daily fee. The objection is to the fact that it's not apportioned pro rata.
Yes, and that of course has been established by the EAT and is not challenged in this.
Yeah.
So the pro rata principle is now being held to apply. That's not challenged, that was an error in relation to the pro rata principle. But the question of the reason is distinct. So if one then, my lord, looks at the EAT's decision, though, at page 36, one sees there the operative sort of summation of the decision on this part, that the alternative basis for the ET's decision is also flawed, as it had erroneously had regard to what it found to be an absence of intention by the respondent to treat the claimant less favourably. Following the decision of the Court of Session, however, it could not be said that ET had erred in requiring that the less favourable treatment was solely on the ground that the claimant was a part-time worker. what I say is that reference to intention was not properly understood in conflict with the approach in JFS. Can I then just take you to a part of JFS, and that's in the authorities bundle at page 200. Sorry, just I found my earlier reference. So if one looks at 184, this is in the head note to JFS.
Yes.
So at B, the first holding of the court, the majority, was that whether there had been discrimination on the ground of sex or race depended upon whether sex or race was the criterion applied as the basis for discrimination, that the motive for discriminating according to that criterion was irrelevant, that the definition of racial grounds in Section 3 included ethnic or national origins, etc. So once again there, one sees the distinction between the ground and motive, not intention. And if one looks at the judgment of Lord Phillips, this is page 200. So Lord Phillips's discussion starts at paragraph 13 in relation to grounds, and then at paragraph 20, one sees again that echo. Whether there has been discrimination on the ground of sex or race depends upon whether sex or race was the criterion applied as the basis for discrimination. The motive for discriminating according to that criterion is not relevant. So if we come back to the amnesty decision, one sees at paragraph 34 there the reference to the mental processes. And one has seen the discussion that has been put in different ways in different cases by reference to what was in the mind or the intention or the motivation. One sees both in the amnesty decision and in the JFS decision is this sharp distinction between motive. So a benign motive does not save a discriminator, and what was in the mind expressed in different ways. So if we come back to the application of those principles, I say that neither McMenemy nor the tribunal below went wrong by reference to intention. The suggestion in the EAT below that those observations could not survive contact, I think, is my learned friend puts it with JFS, I don't accept. One looks at that, they were having regard to the Nagajaran legitimate type of inquiry. But the attempt to then read that across and say, well, the sole approach is bound up with that. Well, in a way it is, because one has to ask oneself, if the provision is not on its face a discriminatory criterion, what is the reason for the treatment? And if the statutory provision requires one to look at what is the sole reason, then that does get one into the terrain of what was in the putative discriminator's mind. What were they seeking to do? So for those reasons, in my submission, this is not a legitimate attack to the approach and the reasoning in McMenemy or to the court below.
And by the court below, you mean the Employment Tribunal rather than the Edis?
That then takes me on to my third topic. I'm speeding up now, which is the suggestion that the regulations may have been intended to have gone further than the directive in a relevant manner. And I accept that it would have been open to the UK to have gone further. One can see that in the directive itself. Framework agreement I'm referring to, which is clause 6 at page 448. Clause 6.1, member states and or social partners may maintain or introduce more favourable provisions than set out in this agreement. Or authorities such as, it's not in the authorities manual, but I think it's controversial. Well, authorities such as Cow and Motor Insurance Bureau, 2016 EWHC 640, Mr. Justice Stewart said at paragraph 27 was, unless there is something in the domestic legislation which suggests that it was intended to be more generous than that found in the directive, the domestic legislation is to be construed first to conform with the directive. What we say is that the appellant in this case has not been able to point to anything to suggest that there was a relevant intention to frame causation in the regulations in a way which is broader than expressed in the directive. And one sees discussion, for example, in the summary in the House of Commons paper, of various ways in which there was discussion as to how broad or narrow the regulations should be framed, for example, in relation to hypothetical comparator. There is no evidential basis for saying that there was an intention to go further in this case. Now, there is this reference in the Matthews decision to the Section 19 enabling power being broader, and that's obviously been shown to you. And I highlighted in my skeleton argument the provision within the House of Commons explanatory note, which explained the way in which it had been considered that the framework agreement, a directive made by way of a framework agreement implemented as a directive, was not capable of dealing with pay. And so to implement pay, the government wishing to go further and address pay as well as conditions, then it was necessary to take a different enabling power. So that is dealt with in my certain argument. At paragraph 47. And if one looks in the House of Commons paper, I've set out in paragraph 47 the text. I'll just take it from there, which is that EU directives can be implemented by regulations under section 2.2 of the European Communities Act 1972, but in this case that would not have allowed them to cover pay as well as conditions. For this reason, the government took power in the Employment Relations Act 1999 to introduce the regulations. The explanatory notes on the Employment Relations Bill explained the power is necessary for its directives which implement framework agreements cannot, by the terms of the agreement on social policy, cover pay. However, in relation to part-time workers, the government believes pay should be covered at the same time as other employment conditions. The powers under the European Communities Act 1972, which are usually used to implement EU directives, are not sufficiently wide to go beyond the scope of the directive in this way, so the clause provides power to do so. So, in that case, one can see from the materials that there was a relevant intention to go beyond the scope of the directive. In fact, it was later clarified by the Court of Justice in IK at headnote H7, that's authorities page 379, that in fact pay was within scope of the directive, but that was not understood to be the case at the time. So then they explained why it was going further. But there is no such indication in relation to causation. And to the contrary, the ministerial statements at the time in my submission reinforced the sense that what was being implemented generally was to reflect the directive and was a measure of relatively minimal intervention. Can I also take you in this regard to page 507 in the House of Commons paper? Sorry, page 524. So at page 523, one sees the last main paragraph in their March 1999 report on part-time working. The Education and Employment Select Committee recommended that the government should introduce legislation guaranteeing women the right to return to work after maternity leave on a part-time basis. And then one sees at 524 at the bottom, the government did not accept this recommendation in its response to the report, although it did suggest a code of practice might encourage this. And if one looks at the top of page 525, the government's response included the line, a statutory right to part-time work would be going beyond what the social partners agreed in the part-time work directive. So again, it's another example where an extension has been argued for, has been considered, and the government has refused to make it on the basis that they did not wish to go beyond what the social partners had agreed in the part-time work directive. So that then takes me to my fourth topic, the additional reasons given by the Court of Session. And one sees those if one takes up the Court of Session's judgment. Paragraph 6. it's the end of paragraph 6. They say, additional reasons for construing the word solely in this way are that, as counsel for the respondents pointed out, there is first no reference in the directive to indirect discrimination, and secondly, different treatment, if established, may nevertheless be justified on objective grounds. And the EAT below suggested that neither of those were anything to the point. Now, in my submission, that is wrong. In relation to the indirect discrimination point, if the part-time worker directive had been framed to give a right, a protection against not only direct discrimination, but indirect discrimination, it would be odd to confine the direct discrimination protection only to cases where the sole reason was discriminatory, when an inquiry under the indirect discrimination analysis could look at a broader range of indirect effects. So, to that extent, it is right that had the directive included protection on grounds of indirect discrimination, as in the case of protected characteristics, that would have been an indicator against adopting an approach of sole causation. And in respect of the justification, again, it is exceptional to be able to justify direct discrimination. On most grounds of protected characteristics, direct discrimination is incapable of justification.
So you can justify discrimination on grounds of age.
Just grounds of age, exactly. And I say that that's actually a relevant comparison, because of course age and part-time worker status both are ones which raise somewhat more blurred lines, as the cases on age discrimination have showed. There are more factors which weigh.
Well, age isn't a binary characteristic.
It's not a binary characteristic, exactly. And indeed, as one sees in this case, there are part-time workers and part-time workers. There are full-time workers and full-time workers. The part-time worker in this case chooses a comparator of a full-time worker who works 90 hours.
Yeah, and as we can see from the facts of Sharma, there can be categories of part-time workers, even with one employer.
Exactly.
Yeah.
So, in relation to justification, my learned friend says, well, you know, if anything, justification is a point in his favour, because these things can all be considered in terms of justification. But what I say is that the fact that it is capable of being objectively justified is another indicator which the Court of Session in McMemory was entitled to take into account as to why the protection, looking at the issue of causation, may be more limited than in other instances of direct discrimination where it is incapable of being justified and is subject to an effective cause test. That takes me finally on to my fifth topic, which is Dwanzub. My learned friend, I think, accepts that the test is compelling reasons, and clearly wrong is just what was described by the Court of Appeal in Dwanzub as the minimum to satisfy compelling reasons. Can I just take the court briefly to Dwanzub at page 334. So this case, which my lady will be very familiar with, concerns a claimant whose severely disabled wife had never worked. Her husband sought a bereavement support payment under the Pension Act after her death. That was refused by the Department for Work and Pensions on the basis that she had not met the National Insurance contribution requirement, and the Administrative Court, Mr. Justice Kerr, upheld the claim, finding that it was possible to construe the Act so as to treat the contribution requirement as satisfied if the person had been unable to work during their working life due to disability. And in so holding, he applied the reasoning of the Northern Ireland Court of Appeal in the case of O'Donnell. He was considering there two analogous statutory provisions. There was a statutory provision in Northern Ireland, and there was another one for England, Wales, and Scotland, which provided materially identically, but not a single provision, as in this case, which applies across the whole of Great Britain. And if one then looks at 352, the first issue, round 1, in the appeal was whether Mr. Justice Kerr erred in treating himself as effectively bound by the Northern Ireland Court of Appeal's decision in relation to the analogous legislation in O'Donnell. And if one then looks forward to paragraph 39 on 353, this is answered by Lord Justice Underhill here. So at 294F, paragraph 41, the judge noted that although understandably Mr. Justice Kerr had directed himself by reference to the decision in Dean, which was another social security decision relating to Northern Ireland, Abbott and Philbin was the leading authority of the House of Lords.
And you don't need to read this out.
No.
Lord Justice Underhill says if a revenue statute applicable to the whole of Great Britain, if you interpret it differently north and south of the border, Abbott and Philbin says you reach rather absurd results, and he says the same applied in Joanchuk.
Yes. And what one sees in Dean, what one sees in the Court of Appeal in Abbott and Philbin, and the approval by the House of Lords in Abbott and Philbin, is this this high bar, and that's accepted by my learned friend. It is a high bar. Let me then move on to deal with, first of all, the point I started with in conversation with my Lord of Justice Bean, this question of conflicting authorities. Can I just take up my skeleton argument in paragraph 9?
How are we doing on time?
Very nearly finished.
Right, near the end. Okay. Your skeleton, paragraph 9.
Yes. So at 9A, the jurisdiction of the EAT is that of a Great Britain-wide single appellate court. And so there is, as the court below explained, in this case, no such thing as the Scottish EAT and the English EAT. There is a single EAT which may sit anywhere, but customarily sits in Scotland and in England. And so when one looks at the different cases that have been cited to the court, if the EAT is sitting in Scotland, as in the Forth Valley Health Board case, hearing an appeal from a Scottish EAT, then it must apply McMenemy. And as I said before, the reasoning of the EAT below must now apply to mean that the EAT in England would also be bound, and an employment tribunal in England would be bound to follow McMenemy. So where does that leave the court? Well, my lord, if one looks in the EAT's judgment below, at paragraph 79, maybe I don't need to go there. It's simply, first of all, the point that if the court here concludes that there are compelling reasons to depart from McMenemy, it will create that fissure in interpretation at the level of the EAT. And I submit, for the reasons I've given you, first of all, that when one looks at the language of the regulations and the directive, and how the directive came to be and what it was seeking to do, one cannot say that McMenemy is wrong at all. Secondly, one certainly cannot say that it is clearly wrong. If the court is with me that it is not wrong, then that's the end of the matter. If the court is of the view that it is wrong, but it is not clearly wrong, then again the matter is clear. The court can express whatever analysis it considers appropriate, which would obviously assist the Supreme Court if it were to hear an appeal in this matter, and it upholds the decision of the AT below in dismissing the appeal. If the court is of the view that it is clearly wrong, then what ought the court to do? Now, I do not accept, by reference to my learned friend's argument, that what differences he has been able to show in relation to how matters were presented in different courts would take one into the terrain canvassed by Lord Justice Underhill at paragraph 45 about differences of presentation of arguments. So what one sees there in paragraph 45 at 355, that the court, Lord Justice Underhill, was keen to emphasise the policy reasons for maintaining a uniformity of approach between the different jurisdictions, applying even if there were differences as to how the cases were presented.
Yeah. Well, that's very well established as well. It also applies to standard precedent in this court. Yeah, yes. Young Bristol Aeroplane. The fact the previous case wasn't very well argued is not the point.
So, my lord, the final point that I would make is that this is an area, employment law, in which there are a large number of unrepresented parties. This is a case, McMenemy, of long standing. It will be referenced in texts, it will be referenced in information online. And were the court to be of the view, which I say it ought not to be, that McMenemy was wrong, and indeed that it was clearly wrong, I would say that it still doesn't attain the level of compelling circumstances when one thinks about the confusion that would be entered into the interpretation of this provision of employment law by holding, in circumstances where there would almost inevitably be an appeal to the Supreme Court anyway, that McMenemy was wrong. So I pray those in aid, and I seek to say this is a different category even to Dwansuk, because in Dwansuk the court was considering two different statutory provisions, albeit statutory analogues in Northern Ireland and the rest of the United and in Great Britain. In this case, one would be ruling for the same piece of legislation of applicability throughout Great Britain, that until the Supreme Court resolves it, the position varies as between Scotland and England and Wales. And I say that that would be another reason why the appellant could not establish compelling reasons in this case. Unless I can assist with anything further.
Thank you very much. Mr. James, no need to repeat anything, of course, but anything to which you wish to reply briefly, then do.
Oh, I'm grateful. If I start with the purpose of the directive, because my learned friend took you to documents, articles which were discussing the background to that. Could I look at the directive, please, page 443? This is I should warn you, minor point, but it's a point which Mr. Mountford made twice, and I thought I should pick up on it, which is, if one looks at recital 11, which I showed you, that recital actually tells you the purpose, because it talks, if you pick it up halfway through, to demonstrating a desire to establish a general framework for eliminating discrimination against part-time workers and to contribute to developing the potential for part-time work on a basis which is acceptable for employers and workers alike. And Mr. Mountford, when he went to that, was reading it as though those last words, on a basis which is acceptable for employers and workers alike, are applicable not only to contributing to developing the potential for part-time work, but also to eliminating discrimination. And he read the same or similar words in the same way on page 446, where you have the preamble to the framework agreement, which makes essentially the same point. But he didn't show you clause 1 on page 447, which I had shown you, but I'm just going to go back to it because you can see there that that first purpose is to remove discrimination, and then the second purpose is developing part-time work on a voluntary basis in a manner which takes account of the needs of employers and workers. The purpose of removing discrimination is, in my submission, a fundamental purpose of this piece of legislation. I entirely accept the points which Mr. Mountford made about it not eliminating indirect discrimination, for example, and having various other restrictions. But there is nothing in any of that, any of the materials which my learned friend showed you, to suggest that insofar as it does make provision in clause 4, it was intended to be narrow, or that the word solely was intended to have the meaning for which my learned friend contends. I said when I took you to this directive that there isn't any particularly illuminating EU authority, and I made the point that my strongest point is really this purposive point, and it's the point which is drawn out in Sharma by the examples which the President gives, discriminating between people on the basis of their age and part-time status, discriminating between part-time workers on the basis of where they work and part-time status. And I cautioned when I made that point that they are imperfect examples. I was focusing actually on the factory one, but it's right to say that the age one is imperfect as well. They are imperfect examples. But I gave other tweaks that you could make to make exactly the same point. I said, what if you've got workers with different categories, different contracts? That's exactly what you see in Sharma. That's exactly what you see in the Carl case, the shorthand writers. So discriminating for two reasons, the kind of contract you have and that you're a part-time worker. Or what about discriminating against part-time workers who work on particular days? Those were the examples which I gave. And Mr. Mountford came back on the admittedly imperfect examples, but not on the tweaks which I had given. And I do say that whilst the imperfect examples are imperfect, the point which they are capturing is a good one. I turn next to the purpose of the regulations. When I took you to section 19 of the Employment Relations Act this morning, I ran into the ground because I thought it had a provision which it didn't have. And I realised over lunch that that was because I wanted you to have the original of the section. And in fact, you'd had the post-Brexit version of the section with the bit I had in mind deleted from it. So I do apologise for that. Could I just hand up the original so that we have it for completeness?
Yes.
So it looks as though Mrs. Justice Edis was looking at the later version, because I think she says somewhere in her judgment that section 19 doesn't refer to the directive.
My lady, that may be right. Yes, I hadn't picked up on that. It was subsection 4, which I was reaching for, which simply says, without prejudice to the generality of this section, the regulations may make any provision which appears to be necessary for the purpose of implementing council directive. And so it is clear that the section has a generality which goes beyond implementing the directive. And to my learned friend's point about pay and so on, had that been the only purpose, of course, this section could only have referred to, as it does in section 4, subsection 4, the need to implement the Council Directive in its application to terms and conditions of employment. So I do say that section 19 assists me. Of course, that is why when you look at that paragraph in Baroness Hale's speech in Matthews that I took you to, she, as you'll have seen, describes this section more in line with the way that I've now shown you.
It's rather odd, though, isn't it, Mr. Jones? Subsection 4 is a power to make provision, but subsection 1 is a duty to make regulations.
Well, it's a duty to make regulations to ensure that they're treated to such extent as the regulations may specify no less favourably.
Yes.
And then 4 is any. Yes, sorry, my lord. I see my lord's point. Yes, a power to make any provision which appears to the Secretary of State to be necessary or expedient.
So they must do that, but they can, if they choose, not make regulations to implement the directive, which cannot possibly be what was intended, but it is what it says.
My lord, it must. I see the point. It must be that subsection 4 is providing a degree of room for judgment in what is necessary or expedient,
yes,
to bring into force the regulations.
Because it begins with without prejudice to the generality of the section.
Yeah.
Yes, yes.
But the empowering subsection is subsection 1.
Yes,
Indeed, it's mandatory.
which is mandatory.
Indeed so. Yeah.
Now,
And to such extent as the regulations may specify. So it's regulations may specify whatever purposes or extent.
yes, it's not limited at all
No.
by reference to the directive.
No.
Now, my little friend submitted to you that there was, as he put it, no evidential basis for the submission that the regulations may go further than the directive. And just pausing there on that language, I'm going to come in a moment to the House of Commons paper. I don't need a factual evidential basis. I'm making an argument about the interpretation of the statute. And my principal basis is the wording of the regulations on the ground that. And I just emphasise that because one does need to be somewhat cautious of the use that is made of the House of Commons paper. It is, I accept, admissible before you as background, but one needs to be cautious. For instance, could we look please at page 507, which my learned friend took you to, and there is there a press notice which says we want to establish minimum standards and so on and so forth. Well, a press notice in a House of Commons paper is not properly admissible to help determine the meaning of a provision such as on the ground that.
Speaking for myself, I think what the House of Commons Library Research paper shows is what areas of concern were being raised and what the reaction to them was, and nobody spotted that, as it were, the McMenemy point was coming down the line.
No.
If they had, the reply might have been very interesting, but the fact that nobody spotted it doesn't mean that on the ground that has to be construed as the session did.
Nobody spotted it. The closest you come, and it's an absence rather than a presence, but if you look at page 518, there is a description of the main provisions, and the third bullet point on that page is just summarising the right in Regulation 5. And it just says part-time workers are given the right not to be treated less favourably than comparable full-time workers unless such treatment is justified on objective grounds other than their part-time status. And actually, if you think about that, it's saying that it needs to be justified on a ground which is something different to the part-time status. So if anything, that supports my approach. I'm saying this again with trepidation because I've not placed reliance on this document. It isn't, I say, admissible to actually construe particular provisions. But insofar as one sees any reference, there it is. And as I understood my learned friend's submissions, the broad gist of what he was putting to you was that in broad terms one sees an attempt in this research paper to take a very narrow approach, and he emphasised various respects in which the regulations don't give protections that they could have given. But on the other hand, my learned friend did accept that in some respects the regulations go broader than they needed to, and he gave the example of employees. And so there isn't, as it were, a clear route through this, or saying Parliament on the back of this paper clearly did the absolute minimum that it had to do. In fact, what happened, as my lord says, is that there was a period of discussion and deliberation, and they moved in certain respects to expand the rights and in other respects to restrict them. In relation to intention, if I can just move on to that heading and my criticisms of McMenemy on intention. You now have the amnesty case as well. I think I've already made clear I don't disagree with the approach in amnesty. It was very prescient and maybe an easier way through it than what the Supreme Court says in JFS. I mentioned Higgs before the adjournment, and I've asked for that to be emailed to your lordships. And I would just mention paragraph 46 in case your lordships wanted a single paragraph description of the point which you've now been taken to several times about the reason why having two different limbs.
Would you like to read it out?
I could, I think.
Oh, I see. No, don't worry. If
I've seen it.
you've seen it. All right, that's fine. I haven't got it here, but of course I've got it in my room. Yes. Okay.
I apologise, my lord. I only had.
That's all right.
I think it was a request for a pithy statement of the test.
That's what it was.
And is that what you're saying, paragraph 46?
It's as pithy as I can find, my lord.
Yeah.
Yes. I did. That sounds like a veiled criticism. It's very pithy, and I hope it's of use to you, my lords. It's certainly shorter than the other explanations that we put before you. Mr. Mountford's submissions on the topic of intention and on the back of amnesty was to say that the court in Gibson and in McMenemy were not wrong to refer to intention, because that can be relevant to the test. And of course I agree it can be relevant. And just to be clear, what is wrong in both of those cases is that they say it is necessary to consider intention. That's what is said at paragraph 6 of McMenemy. This necessitates inquiry into the employer's intention. And it is what is said at paragraph 11 of Gibson. It is necessary to look at intention. And that way of putting it, it is wrong, and it is what led the Employment Tribunal in this case to approach the question on an incorrect footing, because it was not put to the tribunal in this case that there was a subjective intention to discriminate against part-time workers, and that ought not to have been the lens through which the tribunal approached it. It was put on the footing that, I'll give you the reference, core bundle, page 58, I'm reading from the ET1, which is the originating claim form in the Employment Tribunal. The claimant contends, it's paragraph 20, the claimant contends that the requirement to pay the service charges at the specified rates, irrespective of the number of hours worked in any given rate amounted to less favourable treatment of a part-time worker as regards to the terms of the contract, contrary to Regulation 5.1a. So it's always been put in that way, and the error regarding intention is the error of saying that it's always necessary to look at that intention. Finally, and very briefly, just on Zhuangzhuk, of course it's the case that there will, if my lords agree with me, be conflicting authorities in Scotland and England. And of course it's the case that if you don't agree with me, there won't strictly be conflicting authorities in the sense that the courts in England then would have to follow McMenemy. That is, of course, the situation in any case where this court is going to be faced with a Zhuangzhuk type question. So that doesn't take us outside the ordinary run of Zhuangzhuk. It is a high threshold, but that feature of it doesn't make the threshold here any higher than it would be in any other case. My last point is that I can confirm that the spelling of Mrs. Todd's name is correct on the
Thank you.
judgment.
Thank you very much.
It's a very good note on which to end. Any other
No, thank you.
questions? We're very grateful to you both. As I said at the start, we're particularly grateful as our gratitude may be all that you get in but you made a valuable contribution to a rather important debate. We will reserve judgment. We'll send out a draft in the usual way, as counsel know, but I still have to say it in every case. When we send out the draft, point 1 is it's confidential to the parties and their legal advisors until the formal hand down. And point 2, it's been sent out for correction of typos and similar factual errors, not for the case to be re-argued. You know all